When a tenant stops paying rent, many landlords immediately think about eviction. But what you do first can make a major difference. One mistake early on can slow down the process, create confusion, or even make the situation more difficult later on. In this video from AmericanLandlord.com, we'll go over what landlords should generally do first when a tenant falls behind on rent. Please note this video is provided for general information purposes only and does not constitute legal advice. Laws vary by location and may change over time. You may wish to consult a qualified attorney or local housing authority for guidance specific to your situation. When rent goes unpaid, it's important not to panic or react emotionally. The first steps landlords take are often the most important because many states require specific notices, timelines, and procedures before an eviction case can even begin. Before taking formal action, landlords usually want to slow down, verify the facts, and make sure everything is handled correctly from the start. The first thing landlords should do is confirm that the rent is truly late under the lease agreement. Review the lease carefully and verify the due date, any grace period that may apply, the amount currently owed, and whether partial payments were previously accepted. Landlords should also double-check their payment records to make sure the tenant didn't already submit payment either electronically, by mail, or through another method. Next, be sure to review the lease agreement itself. The lease may contain important details regarding late fees, payment methods, notice requirements, partial payment rules, and communication procedures. Some leases even specify where notices must be delivered and how tenants are expected to communicate regarding payment issues. One of the most important things landlords can do early on is maintain clear documentation. This may include copies of the lease, payment ledgers, screenshots of unpaid balances, emails or text messages, and even notes regarding conversations with the tenant. If the situation later escalates into a formal eviction process, organized records may become very important. In some situations, tenants simply forget or experience a temporary issue and intended to pay shortly. A calm and professional message may help clarify the situation before formal action becomes necessary. Landlords generally want to avoid emotional arguments, threats, or statements that could create unnecessary conflict. It's usually best to keep communications brief, factual, and professional. If rent remains unpaid, many states commonly require a formal written notice before an eviction case can begin. In many areas, this may be called a notice to pay rent or quit, rent demand notice, or another similar notice depending on local law. These notices often provide the tenant with a limited amount of time to pay the rent or vacate the property. Because notice periods and delivery requirements vary by state, landlords generally want to confirm the proper procedure before serving any notice. And one important reminder for landlords: many states do not allow self-help eviction tactics. What does that mean? That means landlords should generally avoid actions such as changing locks, shutting off utilities, removing tenant belongings, or harassing tenants to force them out. Removing a tenant usually requires following the formal legal eviction process. If you need help getting started, we offer professionally formatted landlord notices and rental forms, including notice to pay rent or quit forms for various states. You can find them either in the description below or by visiting us online at AmericanLandlord.com.